So welcome everyone, and welcome to this afternoon's session for Lunch and Learn for Accommodation in the BC Human Rights Code. We're very excited to have Adrienne Murray with us today. She's going to lead you through the presentation. Again, if you have any questions as we go through, please just put them in the Q&A and we'll address them as we're going through. Many thanks to this week's webinar sponsor, Bayview Strata and Rental Services on Vancouver Island, and they do the Mid-Island, Upper Island for their property service, so thanks again to them for their sponsorship. And there's a lovely photo of Adrienne that we can all poster now that it'll be part of the presentation, but if you have any questions, Adrienne would also be very happy to get your direct emails, and that's her phone number to reach her directly at the same time. Just a reminder that this webinar is recorded, so don't put any personal or identifying information into your Q&A. Keep it generic. I have a friend who lives in a strata kind of thing. So we'll keep the information out. These are recorded. They do get posted on the CHOA website. So Adrienne, when you're ready, all over to you.
I'm ready, and thank you, Tony, and good afternoon, everyone. Human rights is an interesting issue for many, many strata corporations, and today I'd like to begin by discussing sort of the overall intent of the human rights legislation so that we've got some sort of context to fit in our discussion. And then we're going to narrow our focus, look at the specifics of what constitutes discrimination and what obligations a strata corporation may have if there is potentially discrimination. And then we're going to narrow it right down and look at the various activities that each of the parties, and each of the parties being the person that's requesting some sort of accommodation and the strata corporation. We'll look at what each of the parties has to do. So beginning, as you can see, these are quotes from a decision, Biggins and Park. It related to access to a rental unit, but the terms and the intent of this decision is equally applicable to a strata corporation. So we begin in the biggest context that the goal of human rights legislation is transformative to foster an equitable society. It's intended to ensure that we don't result in the relegation or banishment of disabled persons from participation, which then results in discrimination. And one of the things that I encounter when I talk to strata corporations is the idea that, but our building was like this when the person bought. So we didn't have perhaps handicapped access. We didn't have ramps. We permitted smoking, or we prohibited pets. And for many strata corporations, the existence of what's there today seems to want to drive any decisions that they have. So on the next screen, we see that do we look at what historically we have or what our building looks like? And in fact, when we're going to be examining this, you're going to see that whatever current condition that we have in our building doesn't mean that it's enduring. Just because this condition existed at the time an owner purchased a strata lot doesn't mean it has to stay the same. So when we take a look at, again, another quote from the Human Rights Tribunal, if strata corporations were able to avoid making buildings and facilities accessible on the basis that the owner shouldn't have bought in the building in the first place, individuals with disabilities would obviously be banished to a very specific and limited housing. So just in your mind, imagine that if I'm in a wheelchair and I need to be able to access the doors with a handicapped entry, then if there was no duty on the part of a strata corporation to accommodate my disability, I could only go look to live in a building that already has that handicap feature. And that doesn't fit with the goal of fostering the equitable society. So what we're really looking at, and I know it's sometimes difficult for stratas to accept, but what we're looking at is the total accommodation and the creating an equitable situation amongst individuals with disabilities so that they can live together with individuals without. So strata corporations must understand their obligation in respect to accessibility in order to respond appropriately to requests. So right off the top, the first thing that has to be kept in mind is simply because it was this way when they bought is not an argument to require or to avoid a need for accommodation. Now, we know that strata corporations are subject to provisions of the Human Rights Code, and we have under Section 121 of the Act a specific provision on the next screen that says that a bylaw is not enforceable to the extent that it contravenes the Human Rights Code, with except to age restrictions, and we don't even need to worry about those today. So we know right now that bylaws can't contravene the Human Rights Code, but additionally, it's not just bylaws, it's all the decisions of a strata corporation. So the decision may involve a bylaw, or it may not. It may be a decision of the strata corporation with respect to how common property is used, for example, may have nothing to do with a bylaw. But the Human Rights Code is going to control, to the extent that if there's discrimination, how those decisions are made or how bylaws are enforced. So looking specifically at the code, a person must not, without a bona fide and reasonable justification, deny to a person or class of persons regarding an accommodation, or discriminate against a person or class of persons regarding any accommodation or service normally available based on a whole array of factors. Clearly for us, one of the key ones that we're looking at today will be physical and mental disability. So now, another thing I find interesting in talking to stratas is that I think many of us think we know what discrimination looks like. And when we stand back and we say, well, discrimination is when we prevent a group of people from doing something. So you can't live here because you're from Ireland. You can't live here because you're Jewish. So we've discriminated against a group of people, or the most obvious, you can't live here because of the color of your skin. And that is what I think the average person believes is discrimination. Now, if that was the definition or the identification, then conversely, we would say that if we have a rule that applies to everybody, then we aren't discriminating. And that's, again, another misconception in strata corporations, that as long as we have a bylaw that applies to everybody equally, we can't be discriminating against anyone. But that, again, is not true. Simply because we're treating everyone equally doesn't mean that there isn't discrimination. And the case of Konizna is one of probably the most instructive when we look at this. And it was one of the first cases that we saw in relation to the application of the Human Rights Code in a strata corporation. Now, Mrs. Konizna moved into a building that had a bylaw that required wall-to-wall carpeting. Mrs. Konizna had numerous allergies, and she was allergic to dust mites and formaldehyde and a variety of things that's all in carpeting. So when she went to her doctor advised her that she should remove all the carpeting in her strata lot. But of course, there's a bylaw that says that strata lots have to have wall-to-wall carpeting. So when she went to the strata council refused. They said, no, we have a bylaw. She went back to a medical specialist who said that this carpeting is actually aggravating your the impact of your disease. It's aggravating your allergies. You need to get rid of the carpet. So the strata actually went to the owners and put forward a 3/4 vote to amend the bylaws to remove this bylaw or to make an exception for Mrs. Konizna. And the owners refused. So on that basis, the strata corporation said, well, there's really nothing more we can do. It's a bylaw. The owners refused to change the bylaw. It's unfortunate. Well, Mrs. Konizna went off to the Human Rights Tribunal, and the Human Rights Tribunal agreed with her. And one of the things it said, and one of the arguments that the strata uses, listen, this bylaw is not discriminatory. It applies to everybody. We're not picking on anybody particularly. The Human Rights Tribunal said, although the bylaw is neutral on its face and it applies equally, the complainant, Mrs. Kniezna, is adversely affected by the bylaw because of her disability. The bylaw affects her health and her quality of life in a way it does not for other residents who don't suffer from the same disability. And thus the bylaw adversely affects the complainant by imposing on her a burden which is not imposed on other owners. So I think the Kniezna case helped us understand when we're looking at discrimination, what exactly does that look like? And it isn't a situation where we can simply say, well, there can't be any discrimination if we have the same bylaw. We had a similar outcome in a case of Mr. Shannon. Mr. Shannon lived in Soyuz and wanted to install a solar screen on his window. Now the bylaws prohibited the installation of solar screens, sunshades, different window coverings. But Mr. Shannon suffered from COPD, and the use of his air conditioner aggravated his disabilities. So again, the Strata Corporation said, well, we have a bylaw. It applies equally to everybody. We're not discriminating against you, Mr. Shannon. You need to fit in with everybody else. The Human Rights Tribunal disagreed. So when we're looking at when discrimination can occur, firstly, I think the two key features for strata corporations are simply because it was there when the person bought is immaterial in determining whether we need to accommodate. The second issue is simply because it applies to everyone doesn't mean it isn't discriminatory. Now, this isn't to say that the bylaw in Kniezna or the bylaw in Shannon has to be eliminated. What we're saying is it can't be applied in certain circumstances. So the bylaw on its face is fine. It can apply to 99% of the owners. But if there's an owner who the bylaw impacts differently, then that's when we need to step up and take some action. So, first of all, can the person show that they've been denied a service or received differential treatment? And I think primarily when we're looking at cases with disabilities, we're looking at the differential treatment. Not very often do we see cases where they've actually been denied a service, but in fact, the application of a bylaw affects them differently because of their disability. And most of the time we're going to see, as I've said, the issue is going to be a disability being a physical or a mental disability. Now, the first step must be the complainant must establish that they have a disability. And then we're going to look to see whether the complainant, if they have a disability, can show that they've received differential treatment or denied a service. And the facts must show that the differential treatment or adverse treatment is related to the as a prohibited ground of discrimination. So there's going to be a relationship between the impact on me and my disability. And I'll explain a little bit more about that when we get into looking at some of these cases. But I think it's also important for stratas to recognize that not every case where a person says, I have a disability, is actually a disability. And there's a couple cases that the Human Rights Tribunal have looked at. One of them is a case of Mr. Harton. Mr. Harton wanted a sunshade sunscreen on his balcony in an apartment-style building, and the strata refused. Mr. Harton had a doctor's note that said Mr. Harton has fair skin and he's at risk of developing cancer. On that basis, Mr. Harton said, I have a disability and I'm entitled to an accommodation. But the Human Rights Tribunal disagreed. The Human Rights Tribunal said that having fair skin is not a disability. It's simply a fact, and that there are many things that Mr. Harton can do to prevent or take measures so that he isn't at risk of developing cancer, and a sunscreen is not the only thing he can do. Another situation that came up that was, again, an interesting one at the Human Rights Tribunal was the situation of Mr. Basic. Mr. Basic was in a motorized scooter. Mr. Basic wanted handicapped access put on all of the doors of the building. But when he presented his medical information, the medical information indicated that he had he used the scooter because he was morbidly obese. There was nothing in there that said he couldn't get up, that he couldn't walk, that he couldn't open the doors. So the Strata Corporation wanted additional medical information, and Mr. Basic refused. When it went to the Human Rights Tribunal, the Human Rights Tribunal ordered that in order to make a decision, additional information about Mr. Basic's medical circumstances, its impact on his mobility, was all going to be necessary in order to reach a decision. So a couple of things with disability is first of all, even in Mr. Basic's case, although it might appear almost obvious, it's sometimes worth asking some more questions. What exactly does this disability prevent you from doing? What's the nature of the disability in detail? Is it truly a disability? And then the next question is, even if we have a disability, is what is being asked for necessary in relation to the disability? And the Human Rights Tribunal often talks about this as a nexus between what I want and what my disability is. And here's another example of this is Mr. Ross. Mr. Ross was in a wheelchair. He lived on the main floor of an apartment building. He could access his apartment through the front entrance. He could get into his suite, and he had a patio at the back. But what Mr. Ross wanted was he wanted a gate put in the fence that was around his patio, and he wanted a pathway out to the street, because that would make it easier to access the public sidewalk. He wouldn't have to go through the building and down the front path in order to access the sidewalk. So when the Human Rights Tribunal looked at that, and the Strata had refused, obviously, so it's gone to the Human Rights Tribunal, but the Human Rights Tribunal said that what you're seeking is not a necessity. You would find it useful, but it isn't a necessity in terms of your disability, because you have access to the building, to the sidewalk, to your strata lot, to your patio. You have full access. You just want this as a convenience. So they refused. So that's the nexus that has to be established. And sometimes that's not always obvious or easy. And so asking questions and gathering the appropriate and credible information, and maybe seeking professional help, is necessary in order for the Strata Corporation to deal with the requests that it's receiving, understanding whether there's a disability and understanding whether what's being asked for is in fact a requirement and necessary for the disability. So when we have once we have a case of discrimination, and again, the terminology in the Human Rights Tribunal is a case of prima facie discrimination. It looks like discrimination on its face. And so once we have that, where the person has a disability and is saying, I am being affected by this decision as a result of my disability. I'm Mrs. Kniezna and my allergies are getting worse. I'm Mr. Shannon and I'm having trouble breathing because I can't turn my air conditioner on. So once I've established both the disability and that there's an adverse impact from the disability in relation to the decision, now the onus flips over to the Strata Corporation. and it must show that it has accommodated the person. And we see the term accommodation frequently. We're going to talk about accommodation. This is a term under the Human Rights Code. So the three factors that have to be considered, first of all, was the action reasonably necessary to accomplish a legitimate purpose? And usually this isn't a hard one for the strata to answer. The answer is almost always yes. Was the action implemented in good faith on the belief that it was necessary? Again, this one is usually pretty straightforward, and the answer is yes. In fact, I'm not even sure we've seen a case where we could say an action was implemented in bad faith, specifically against an individual. So normally what the strata is doing is reasonable, and there's a reason for it, but then there's number three. Can the strata corporation show that it couldn't meet its goal and still accommodate the person without incurring undue hardship? And that's the real key now. So once we've got prima facie discrimination, now we've got the strata corporation saying, all right, how do we accommodate you, and to what point must we accommodate you? And undue hardship may arise if further accommodation is impossible or can only occur at excessive cost. Excessive cost is going to be relative. It's going to depend on the assets of the building, the assets of the owners. And so simply because something might look expensive, that's not going to eliminate the possibility right off the bat. So in terms of accommodation now, the process is one in which all those involved are required to work together. This isn't one person or the other. It isn't the person seeking accommodation or the strata corporation that has the sole job of figuring out what the accommodation is going to look like. But we again have the human rights saying, well, an applicant can make suggestions or requests. It's the strata corporation who's in the best position to determine how the person can best be accommodated without undue interference in the strata property. Now, this came out of a case where there was an issue with the disconnection of a doorbell. And so when we're talking about the strata corporation being in the best position, we're probably talking more in terms of alterations to common property and what the strata corporation can do, what it can afford to do, what it can get a permit to do. So there's a whole bunch of factors, and that's not the job of the owner to figure out. That's the job of the strata corporation. So very quickly, just so that there's no confusion, obviously a strata corporation has to accommodate owners, but it also has to accommodate tenants. We have a case at the HRT, the Human Rights Tribunal, that has identified that tenants are also part of the discussion. And interestingly as well, we've got a case where a strata corporation was found to have discriminated against a prospective purchaser because they refused to permit that prospective purchaser's pet. So be careful. Accommodate owners, accommodate tenants, and there may be circumstances where a prospective purchaser may also need to be accommodated. So there's many variations of accommodation for access and alterations for a variety of reasons, and in each case may have valid claims. I think the key here is that each case needs to be assessed on the merits of the application, the obligation of the community to accommodate. So if you start with the right attitude, and the attitude that we're here to create an equal society, you have a disability, and we need to look at ways that we can make it work for you, so to speak. But disabilities and needs for accommodation are going to be as varied as there are strata corporations and individuals. So there isn't a one-size-fits-all. It's never possible to say, yes, in these cases, this is always what has to happen. So important to take a look at the various issues and gather the information. Now, things like access, entry and facility ramps, power stair lifts, electronic door openers, levered door handles, swimming pool ramps, 24-hour access, stairwell handles. These are just a few of the things that strata corporations can come up against when needing to accommodate access within a strata development, increasing the size of doorways into strata lots, making alterations within strata lots that may require approval. All of this, some of it is common property, some of it may well be within the strata lot. Other types of accommodations that we're seeing, things like air conditioners, air filtration systems, alterations to suites for access, pets that are contrary to the bylaws, live-in caregivers with age bylaws. And I just want to mention the issue of pets again. I don't want to dwell on this, but another misconception that I'm seeing with stratas is that because of the change in legislation that says that a strata cannot discriminate against certified guide dogs, there are some stratas that believe that if my pet isn't certified, that's the end of the matter. There's no further discussion on accommodation. And that again is not correct. If my pet is not certified, then the strata corporation may still have a duty to accommodate me on the basis that we've just been talking about. If the decision of the strata to prohibit my pet impacts my disability. So it isn't, again, there's, I think that just sort of goes to show how complicated this can be, and there's never a one-size-fits-all, and there's never an absolute answer when we're looking at this. There may be need to accommodate pets that are not certified. So that's sort of a quick summary of some of the access and accommodation issues. But now, what are we going to do with that request? So first of all, I think the key for stratas, and this applies in many circumstances, but certainly when we're dealing with accommodations of requests for disability, is to obtain a written confirmation of the request, including the details of the alteration. But of course, you're also going to confirm that there's a disability, and you're going to establish that there's a valid claim for the alteration. That's the nexus that we're talking about. So in this first point, that's a lot of information to gather. And owners are obligated, owners or tenants, if that's the case, are obligated to provide the strata with sufficient information to make that decision. We've had one case where the strata corporation requested additional information about a disability, and the doctor indicated that that was private information. Well, the Human Rights Tribunal said, no, if you're requesting an accommodation for a disability, you have an obligation to make sure that the strata corporation understands what your disability is and understands the impact of that disability. So step one, gathering all of the facts and confirming what the disability is, what the accommodation is that's being requested, and how the two relate. Confirm that what is required is necessary to accommodate the disability. Is it something that's necessary for access, or is it a case like Mr. Ross, where it's simply a convenient or would be a nice to have, but not necessary? And again, in some of these cases, stratas may need to gain additional and gather additional professional advice. There may be information that we need from engineers. There may be legal advice we need. You may want to get a sense of what the CRT has done in other circumstances like this. So gathering all of the background facts may help a strata corporation make a decision. We're going to confirm in writing to the applicant owner the details of the alteration and the specifications of what they want. And this is not just a one-time event. This may take a lot of back and forth, toing and froing between the owner and the strata. Owners are obligated to communicate and cooperate with strata corporations. And so there's a process here that isn't just simply tell me what you want and put it in writing. So there's a lot of back and forth. They're going to have to confirm responsibility for costs. If we're looking for alterations to common property, that will be a strata corporation expense most of the time. If it's alterations within a strata lot, obviously the opposite. Council then needs to meet to decide on whether the application is reasonable. Now, something that we sometimes see here is requests for alterations and perhaps related to a disability in a hearing. And you'll remember that the Strata Council has a week to provide their response to the hearing. If you at that hearing don't have enough information, the important issue is to indicate to the owner that the application is denied and this is what we need. Simply indicating to owners, well, we don't have enough information, leaves it out in no man's land. It's out in limbo. And I think it's always important whenever there's been a request for a decision made at a hearing for strata councils to finalize that decision. If you don't have enough information at this time, then the decision must be no. It's a no but. No but if you could provide this and this and this. Perhaps we need to know some issues around the building code or building permits, or we need an engineer's report. So you may not have that information now, so you may not be able to say yes, but you can indicate for sure what the answer is. Today it's no, but indicate also what else is necessary. So once we've gone through that process then, let's look in detail about what each of the parties need to do. Now we have the case of Leary, and Leary is a decision about smoking, and an individual who has complained to the Strata Corporation about secondhand smoke. So although it's related to a particular issue, the analysis and the tests that were set out in Leary have a much broader application. So it also takes a look at what the role is of each party. What's the applicant's process and what's the Strata Corporation's process? So let's look first at the applicant. It's important for this applicant to advise the Strata Council of their disability. They have to provide enough information for the Strata Council to understand that they have a disability and that it's negatively affected, in this case by secondhand smoke, but in a broader context, that it's negatively affected by the decision of the Strata Council or by the bylaw that the Strata Corporation is trying to enforce. So make sure that the Strata has all the information that is necessary to put the entire request for the accommodation into context in relation to the disability. Cooperate with the Strata to provide sufficient medical evidence. And this may include a medical report. A brief note on a doctor's prescription pad is probably not going to be comprehensive enough to establish the need for accommodation and allow the parties to understand what the options are. And we see this time and time again, a doctor's prescription pad, Adrienne needs a pet. Well, Leary is the absolute case that tells us that's just not good enough. We need to have an understanding of the medical disability that's at the root of the problem and how the accommodation of whatever it is going to fit with that medical diagnosis. So cooperate with the Strata to discuss possible solutions. It's rare that there is ever just one solution. And the person seeking the accommodation is not entitled to the perfect accommodation, but to one that reasonably addresses their needs and upholds their dignity in housing. So it's, again, a dialogue. It's the cooperation. It's the discussion and communication between the parties. Unfortunately, what we see in many cases, or maybe just by the time it comes to my office, is we've seen this turn into an adversarial process where the parties are somewhat entrenched in their position and the ability to communicate and create that dialogue has been lost, or is going to take a lot of work to repair. And my recommendation to you, again, is if you approach it, at least from the Strata Corporation's point of view, if you approach it with the attitude that we're here to try and create equality amongst our owners, then we're going to approach it, I think, perhaps in a slightly more progressive way. So Perfection isn't the answer, but an accommodation that permits the person to reside in the building with their dignity and to address the issue at hand in relation to their disability. And finally, they must cooperate with professionals and others who may be involved to explore accommodation solutions. As I say, there may be a variety of solutions, many we haven't yet thought of. So opening up the dialogue, talking to people who are professionals in the area, whether it's people who are experienced in accommodation or construction or the legal issues or professional engineers, whoever it may be, listen to what they have to say and analyze what their suggestions are. So that's the role of the owner. The role of the strata: address the requests promptly and take them seriously. And that sentence is probably one of the most important in the presentation. It's surprising to me the number of strata councils that sometimes dismiss out of hand a request for an accommodation. That would be the wrong approach in every case. Don't dismiss it. Don't assume you know what's going on. Don't assume that they're there just to cause you trouble. Address it promptly and take it seriously. Consider how you're going to process this accommodation on a timely basis. And again, this isn't usually here's my request and we give the decision. So you may want to appoint someone from the council as your point person to communicate with the individual and bring the information back to council. Make sure that you've got someone who understands the need to accommodate, understands some of the basics, and then works on this cooperative, communicative process. Gather enough information to understand the nature and extent of the need for the accommodation. The strata is entitled to request medical information that's related to the request. So you're not entitled to get more than what you need, but you are entitled to get enough information to actually analyze what's going on, analyze what the implications of this decision or bylaw is on this disability, and then enough information that allows you to say, well, if we do this, then this will address the problem. So there's a fair amount of personal information that's going to have to be gathered by the strata, and understand that that's going to be part of the process. I don't view any of these requests for accommodation, as I said, as a once and done kind of thing. It's a process that both parties need to participate in. But now once you've restricted, or once you've gathered all of this medical information, it's critical that this information is protected. This is very private, personal information that must be restricted in terms of making its availability. Now, this is coming out of the decision of the Human Rights Tribunal in the Levy decision. I know that there's some conflicting information out of the Civil Resolution Tribunal that has taken the view in at least one case where that medical information is part of the information received by a strata corporation that is available. My recommendation here, and I'm always, I apologize when I say this, but you may want to get some legal advice if you're being asked to release that medical information. So you've got privacy issues, you've got human rights issues, and then you've got the CRT that seems to be taking a slightly different view. So before I would release this information, I would insist on getting some legal advice, and likely that advice is going to be, at least it would be from me, that we won't release it till we actually get an order to release it. I would not be releasing medical information simply on the basis of a request. So we've protected the personal information, we've got the medical information. The other thing we may need are expert opinions and advice. Now, in the case that we're talking about here with the smoke, In Leary, sorry, I said Levy, Leary, a sniff test undertaken by another strata member may not be sufficient to evaluate the extent of the problem. So we may need an air quality expert to be brought in. And in Leary, it tells us that the strata corporation should pay for these tests or expert reports. Now, again, that's a general statement in Leary, and that's probably appropriate on the first time. If we're being asked for report number 2 and report number 3, again, this may be something the strata wants to get legal advice on, because I do think that we've got other decisions of the CRT, at least, that talk about being reasonable in requests that owners make. So again, it's this balance of the need to accommodate from the human rights perspective. We've got some CRT decisions out there. So ideally, certainly the first evaluation isn't an issue. I think if you've got multiple requests for expert reports, that may be something that we need to take a second look at. But again, important to gather the facts. And finally, take the lead in investigating possible solutions. As we pointed out from the case before with the doorbell, the person who's best equipped to deal with alterations to common property and decisions in relation to the operation of the strata corporation is the strata corporation, the strata council. So they're the ones that know this information best and are able to come up with solutions. So that's the strata corporation's role. But of course, there's always the need for cooperation. And finally, rigorously assess whether the strata can implement an appropriate accommodation solution. In doing so, you may have to consider financial cost, the competing needs of other strata members with disabilities. In some cases, a solution may not be possible without suffering undue hardship. But again, we need to be careful about what we define as undue hardship, because our idea of undue hardship and the Human Rights Tribunal may be a little bit different. And certainly we saw that in the case of Mrs. Holloway-Chuck, who wanted a ramp put up in the lobby that had 3 stairs. And Mrs. Holloway-Chuck was in her 90s and walked with a walker. And one of the strata's arguments was this was just too expensive. But at the Human Rights Tribunal, they didn't demonstrate or didn't provide evidence of how much was in the contingency reserve fund, the financial status of the owners in the building. So we need to be very careful not to jump quickly to the idea of this is an undue hardship. But clearly there may be cases where that arises. But again, I think I come back to the idea of if we're using our cooperative and communicative skills and we can understand what the issues are, there may be a variety of solutions. Perfect solution may be unaffordable or impossible because of the structure of the building, but there may be another solution, another means of accommodating that will get us to where we need to go. So when we're looking at this, and the Leary test is useful because we've got both a role for an owner and the role for the strata corporation. And accommodation is going to have a variety of conditions. It's going to have a variety of results. But we see from Leary that we've got a useful checklist when we're reviewing our applications. So a decision to permit an accommodation under the bylaws is solely a decision of the strata council. It can't be delegated to the property manager, singular party, and it can't be flipped back to the owners. We saw that in Conisna, where the strata council said, well, this is a bylaw, and if you want to act in a contrary way, we need to get the permission of the owners. And of course, the owners rejected it. And the HRT, the Human Rights Tribunal, was very clear that we cannot leave the accommodation of a minority, an individual with a disability, to a 3/4 vote. This is a decision of the council, and the council has the right to not apply a bylaw or apply it in a different way in order to accommodate a disability. So, Tony, that's the presentation.
And we're at question time. Thank you, Adrienne. That was excellent. I'll just go through kind of a summary. There were a lot of great questions. Several of them you actually answered very well as it went through the presentation, which we really expected. But there's also some excellent additional questions that just kind of are a little bit more granular on specific topics. The first one is, a strata has 2 grandfathered smokers in our building, but they have complaints about the smokers. Can they go back and undo the resolution that approved the grandfathering?
Well, I think that raises actually 2 points. We do have a case from the CRT that says there is no such thing as grandfathering, and that a bylaw that is passed, other than in the situations in the Strata Property Act, which accommodate existing circumstances, the Act doesn't use grandfathering, but we know that if you've got pets in place at the time a new pet bylaw is passed, or you've got kids in place at the time an age bylaw is passed, you get to keep the pets and the kids. And also, if we have a rental, there are delaying provisions in rental. But other than those 3 circumstances, the CRT has said that the Act itself doesn't have grandfathering provisions. That puts into question a bylaw that permits grandfathering. So now, leaving that aside, we have a bylaw, or the bylaw itself grandfathers, I'm assuming. Couple of things can happen. Notwithstanding the grandfathering, and I'd want to look at the bylaw to make sure that they didn't grandfather them out of all the other provisions of the bylaws, but I'm assuming that you have also a bylaw that prohibits people from creating nuisance, and so the smoking may actually be a nuisance. So while you've grandfathered them on the smoking bylaw, as long as you haven't grandfathered them from the application of a nuisance bylaw, the Strata Corporation should be able to go and apply the nuisance bylaw. And then, of course, the other option is to amend the bylaw and remove the grandfathering provision, partly on the basis that there's really no contemplation of this kind of grandfathering in the Strata Property Act.
Thank you. So next question relates to age restrictions. So we know that under the Human Rights Code and the Strata Property Act, the Strata Corporation is permitted to have age restrictions, 19 and over, 55 and over, other ages that relate to occupancy. But the other side of that is how does the Strata Corporation deal with a 55 and over bylaw for occupants, but now you have individuals with caregivers?
Well, when I'm drafting, first of all, we have to accommodate the disability. So the process is exactly the same that I've just gone through. Is there a disability? And is the prohibition on anybody under 55 impacting this disability in a negative way? Now, are there caregivers who are 55 and over? Maybe not. Maybe we have to have a caregiver. What we want to do is make sure that we're following the process. So we know that there's a disability. Has the doctor, is there medical evidence that a caregiver is necessary? Does the caregiver have the medical qualifications to be a caregiver, or is it the owner's niece without any caregiving skills at all? So again, a lot of questions. When I draft age restrictions for stratas that may want to accommodate a caregiver, we include the requirement that caregivers are permitted provided that there's medical evidence that it's necessary and the caregiver meets the appropriate qualifications as established by the medical professional. So there's certainly ways around it. If you don't have that in your bylaw, you're still going to need to accommodate, but follow this process that we've just gone through. Establish the disability, establish the connection between the impact on the person, establish that there's no other way of accommodating. is the caregiver planning to come with and move in with 2 children? You know, that would again be a different set of circumstances. So we may permit the caregiver who's not 55. What are the other factors there? But it's really the same process for accommodation.
Right. So, and another question goes to the use of property, and I'm sure if this strata's insurance company were aware of this behavior, they would be horrified, and so would the resulting strata at the cost and the liabilities. But their strata is slow to remove snow and ice from their common areas, and an owner walks with a walker and advised them that it is a safety risk for them. And the strata's response back to the owner was, well, you're the only one with a walker, so that's your problem. So a little horrifying on a whole bunch of fronts, but would that type of response or behavior constitute a human rights complaint?
Well, just as you've said, this is on so many levels problematic. But yes, I mean, I think so. I think what we're saying to a person is my decision to not remove the snow, leaving aside all the other liability issues and insurance issues, my decision to not remove the snow impacts you particularly because you have a walker. And that looks to me like prima facie discrimination.
Yeah, exactly. Who pays for the request in a townhouse complex when somebody wants to put in a front ramp, but it covers across the common property? Or is this just treated like a routine alteration to common property request by an owner?
If we're in a townhouse, if it's solely related to the use of that townhouse, I think there is an argument, and again, we're dealing with limited facts, but I think there's an argument that it's an alteration to common property requested by the owner. And in terms of the request, there will be issues because it is on common property that the strata wants to ensure in terms of its safety, its code requirements, perhaps that it be removed when the strata lot is sold or the person no longer requires it. So there's a lot of factors at play in that one, including cost.
You'll like this because this comes up almost on a daily basis now. So are we discriminating against an owner who has purchased an electric car, but we have no charging stations? Do we have to put one in?
Well, I think if we had owners of electric cars as a category in Section 8 of the Human Rights Code, yes, but other than that, no.
Well, and it does go back to the same point that we've seen the perspective of buyers who move in, and we've had this problem with individuals who bought vehicles too large to enter the building and then drive their building in. It's very much, be aware of your location and audience before you purchase.
Of course, of course. Now let's flip that around and say it's not an electric vehicle, but it's an electric scooter.
Right.
Do you have to accommodate me by providing a means of electricity? And I think, again, the question would be, is the scooter for my convenience? Is it necessary? Is there a disability? So I think the questions are interesting because it shows us that when we go back, no matter what the issue is, we go back and follow the same process. We follow this criteria of evaluating the disability, the impact on the individual. Is the impact caused as a result of the disability and the decision of the council, that nexus? What's the accommodation? So the process stays the same whether we're talking about electric vehicles, electric scooters, ramps, the whole thing.
And I think it kind of goes back to the kind of practicality of what we do as well. So, because there's another question here of putting in automatic door openers in a building if owners request them. They don't necessarily have a disability, but they have few older persons in the building. A strata corporation can simply start with the process of going to the owners at a general meeting and saying, can we get approval to install and upgrade our door systems for easy entry for everybody in the building? Why are we waiting until you get into a human rights challenge to deal with some of these issues?
Well, absolutely. And even though somebody doesn't have a disability today, when we're in a building that we're looking for people to age in place, and we're looking for an ability to have a community that's as varied as possible, why wouldn't we want to make buildings as accessible as you could possibly make them?
And there is actually a substantial amount of grant money available through the HAVIT program at BC Housing, both for individual units to do upgrades for accommodation and for common areas. So oftentimes you can actually have these expenses covered.
Well, and that's, again, all the more reason why strata should be looking at this closely.
One more question, and I think we've kind of looped them all around. Who's responsible, the age-old question, for the cost of the accommodation if it only benefits the applicant?
Well, again, I think we really need to look at what we're accommodating, or what we're altering. If we looked at the ramp in Mrs. Holloway-Chuck, Mrs. Holloway-Chuck lived in a building that had 3 stairs. You came in the entrance, 3 stairs to get to the elevators. And as I said, she walked with a walker and had very often had difficulty navigating the stairs. She asked for a ramp. That, no doubt, would be a strata corporation expense. Mrs. Holloway-Chuck would not put in a ramp on common property in the lobby that would be used by others. That would not be expected to be an expense of hers. Where we're talking a townhouse that the ramp is necessary only for access to the townhouse, that may be a different story. So again, we need the facts. We need to understand where this is going, who's going to use it, how long it's going to be there. All of that information needs to be gathered in order to make an informed decision.
Moral of the story: gather information and don't make up your mind until you have all the information.
Absolutely, absolutely.
Adrienne, thanks so much. That was wonderful.
Thank you, everyone. I hope you've enjoyed that. You've got my email, so if you've got questions or specific concerns, don't hesitate to send me an email, and I'll do my best to get back to you quickly.
Thanks so much.
Thanks, everybody. Bye.
Hopefully everyone continues to be safe.